Hello, everyone. Good day. My name is Michelle Gay A. Palasan. Today, we will talk about the administrative matter number 01-7-01-SC, also known as the Rules on Electronic Evidence. Let's define what is an electronic evidence. It is an evidence wherein the use of which is sanctioned by existing rules of evidence. In ascertaining in a judicial proceeding the truth respecting a matter of fact, which evidence is received, recorded, transmitted, stored, processed, retrieved, or produced electronically. Scope. The general rule The rules on electronic evidence shall apply whenever an electronic document or electronic data message is offered or used in evidence. Exception: when otherwise provided. Cases covered. The rules apply to all civil actions and proceedings as well as quasi-judicial and administrative cases. However, according to People v. Enojas, the rules may also apply to criminal cases. Electronic data message. An electronic data message is an information generated, sent, received, or stored by electronic, optical, or similar means. Electronic document. An electronic document is an information or the representation of information, data, figures, symbols, or other modes of written expression described by or however represented by which a right is established or an obligation extinguished or by which a fact may be proved and affirmed, which is received, recorded, transmitted, stored, processed, retrieved, or produced electronically. It includes digitally signed documents and any print out or output readable by sight or other means which accurately reflects the electronic data message or electronic document. For purposes of these rules, the term electronic document may be used interchangeably with electronic data message. Whenever a rule of evidence refers to the term writing, document, record, instrument, memorandum, or any other form of writing, such term shall be deemed to include an electronic document as defined in these rules. Electronic signature. An electronic signature is any distinctive mark, characteristic, and/or sound in any electronic form representing the identity of a person and attached to or logically associated with the electronic data message or electronic document or any methodology or procedure employed or adopted by a person and executed or adopted by which person with the intention of authenticating, signing, or approving an electronic data message or electronic document. For purposes of these rules, an electronic signature includes digital signatures. Digital signature. A digital signature is an electronic signature consisting of a transformation of an electronic document or an electronic data message using an asymmetric or public crypto system such that a person having the initial untransformed electronic document and the signer's public key can accurately determine whether the transformation was created using the private key that corresponds to the signer's public key, and whether the initial electronic document had been altered after the transformation was made. Ephemeral electronic communication. An ephemeral electronic communication is a telephone conversation, text messages, chat room sessions, streaming audio, streaming video, and other electronic forms of communication the evidence of which is not recorded or retained. Factors that may be considered in assessing evidentiary weight: the reliability of the manner or method in which it was generated, stored, or communicated, including but not limited to input and output procedures, controls, tests, and checks for accuracy and reliability of the electronic data message or document, in the light of all the circumstances as well as any relevant agreement. The reliability of the manner in which its originator was identified, the integrity of the information and communication system in which it is recorded or stored, including but not limited to the hardware and computer programs or software used, as well as the programming errors. The familiarity of the witness or the person who made the entry with the communication and information system, the nature and quality of the information which went into the communication and information system upon which the electronic data message or electronic document was based, or other factors which the court may consider as affecting the accuracy or integrity of the electronic document or electronic data message. Method of proof: all matters relating to the admissibility and evidentiary weight may be established by an affidavit stating facts of direct personal knowledge of the affiant, or facts based on authentic records, and affirmatively showing the competence of the affiant to testify on the matters contained therein. The affiant shall be made to affirm the contents of the affidavit in open court and may be cross-examined as a matter of right. Burden of proof: the person seeking to introduce an electronic document in any legal proceeding has the burden of proving its authenticity in the manner provided in this rule. Manner of authentication of private electronic document offered as authentic by evidence that it had been digitally signed by the person purported to have signed the same, by evidence that other appropriate security procedures or devices may be authorized by the Supreme Court or by law for authentication of electronic documents where applied to the document, or by other evidence showing its integrity and reliability to the satisfaction of the judge. A document electronically notarized in accordance with the rules promulgated by the Supreme Court shall be considered as a public document and proved as a notarial document under the rules of court. Manner of authentication of electronic signature by evidence that a method or process was utilized to establish a digital signature, and verify the same by any other means provided by law or by any other means satisfactory to the judge as establishing the genuineness of the electronic signature. General rule: hearsay rule does not apply to a memorandum, report, record, or data compilation of acts, events, conditions, opinions, or diagnoses made by electronic, optical, or other similar means at or near the time of or from transmission or supply of information by a person with knowledge thereof, kept in the regular course or conduct of a business activity, and such was the regular practice to make the memorandum, report, record, or data compilation by electronic, optical, or similar means, and shown by the testimony of the custodian or other qualified witnesses. Exception: the presumption may be overcome by evidence of the untrustworthiness of the source of information or the method or circumstances of the preparation, transmission, or storage thereof. Audio, photographic, and video evidence of events, acts, or transactions must be shown, presented, or displayed to the court, and shall be identified explained or authenticated by the person who made the recording or by some other person competent to testify on the accuracy thereof. Ephemeral electronic communications, proven by the testimony of a person who was a party to the same or has personal knowledge thereof. In the absence or unavailability of such witnesses, other competent evidence may be admitted. Recording of the telephone conversation or ephemeral electronic communication, same as audio, photo, and video evidence. If recorded or embodied in an electronic document, provisions of Rule 5, which is the authentication of electronic documents, shall apply. Let's check out this case. RCBC Bank Card Services Corporation versus Moises Oracion Jr. and Emily L. Oracion. GR number 223274. The facts of the case. It is a complaint for sum of money against the spouses Oracion for non-payment of credit card debts. RCBC Bank Card Services Corporation attached to its complaint duplicate original copies of the statements of accounts and the credit history inquiry under the name of Moises Oracion. The MEDC, upon receipt of the complaint, found the same covered by the rule on summary procedure when the spouses did not file their answer. The MEDC submitted a case resolution. In its ruling, the MEDC dismissed the complaint for failure of RCBC to prove its case by preponderance of evidence, noting that it did not submit the original copies of the documents attached to the complaint in violation of the best evidence rule. On appeal to the RTC, the latter dismissed the appeal. It noted that the documents submitted by the appellant were mere photocopies of the originals, with the notation duplicate originals. Even the signature appearing on the stamp marks were not originals. Even the manifestations submitted by RCBC were photocopies of the annexes. Thus, the RTC agree with the MEDC that RCBC failed to comply with the best evidence rule. On pure question of law, RCBC appealed to the Supreme Court. It invoked for the first time an appeal that the annexes attached to the complaint were electronic evidence and must be considered as such. It also pleaded those technicalities should be set aside so that the merits of the case should be treated out. The issue of the case is whether or not the annexes attached to the complaint are electronic evidence. Ruling no. For the court to consider an electronic document as evidence, it must pass the test of admissibility. According to Section 2, Rule 3 of the Rules on Electronic Evidence, an electronic document is admissible in evidence if it complies with the rules on admissibility prescribed by the rules of court and related laws, and is authenticated in the manner prescribed by these rules. Rule 5 of the Rules on Electronic Evidence lays down the authentication process of electronic documents. Section 1 of Rule 5 imposes upon the party seeking to introduce an electronic document in any legal proceeding the burden of proving its authenticity in the manner provided therein. Section 2 of Rule 5 sets forth the required proof of authentication. Section 2, Manner of Authentication. Before any private electronic document offered as authentic is received in evidence, its authenticity must be proved by any of the following means: by evidence that it had been digitally signed by the person purported to have signed the same, by evidence that other appropriate security procedures or devices as may be authorized by the Supreme Court or by law for authentication of electronic documents. were applied to the document, or by other evidence showing its integrity and reliability to the satisfaction of the judge. As to method of proof, Section 1, Rule 9 of the Rules on Electronic Evidence provides Section 1, Affidavit of Evidence. All matters relating to the admissibility and evidentiary weight of an electronic document may be established by an affidavit stating facts of direct personal knowledge of the affiant or based on authentic records. The affidavit must affirmatively show the competence of the affiant to testify on the matters contained therein. Evidently, petitioner should not have complied with the rules and evidence on electronic evidence because it failed to authenticate the supposed electronic documents through the required affidavit of evidence. As earlier pointed out, what petitioner had in mind at the inception when it filed the complaint was to have the annexes admitted as duplicate originals, as the term is understood, in relation to the paper-based documents. Thus, the annexes or attachments to the complaint of petitioner are inadmissible as electronic documents, and they cannot be given any probative value. Let's check out a bar question. State the rule on the admissibility of an electronic evidence. The suggested answer: whenever a rule of evidence refers to the term writing, document, record, instrument, memorandum, or any other form of writing, such term shall be deemed to include an electronic document as defined in the rules. An electronic document is admissible in evidence if it complies with the rules on admissibility prescribed by the rules of court and related laws and is authenticated in the manner prescribed by the rules. The authenticity of any private electronic document must be proved by evidence that it had been digitally signed and other appropriate security measures have been applied. Let's go to the next bar question. When is an electronic evidence regarded as being the equivalent of an original document under the best evidence rule? Suggested answer: an electronic document shall be regarded as the equivalent of an original document under the best evidence rule if it is a printout or output readable by sight or other means shown to reflect the data accurately. Next bar question. On March 12, 2008, Mabini was charged with murder for fatally stabbing Emilio. To prove the qualifying circumstance of evidence premeditation, the prosecution introduced on December 11, 2009, a text message which Mabini's estranged wife, Gregoria, had sent to Emilio on the eve of his death, reading, "Honey, papatayin you ni Mabini. Matagal na niyang plano ito. Mag-ingat you, baka matsugi ka." Suppose that shortly before he expired, Emilio was able to send a text message to his wife, Christiana, reading, "Nasaksak ako. Di na mi makahinga. Si Mabini ang may gawa nito." Is this text admissible as a dying declaration? Explain. The suggested answer is yes. The text message is admissible as a dying declaration since the same came from the victim who shortly expired, and it is in respect of the cause and circumstance of his death. The decisive factor that the message was made and sent under consciousness of an impending death is evidently attendant from the victim's statement, "Di na mi makakahinga," and the fact that he died shortly after he sent the message. However, cell phone messages are regarded as electronic evidence, and in Ang versus Court of Appeals, GR number 182835, April 20, 2010, the Supreme Court ruled that the rules on electronic evidence applies only to civil actions, quasi-judicial proceedings, and administrative proceeding, not to criminal actions. Next bar question. While window shopping at the mall, On August 4, 2008, Dante lost his organizer, including his credit card and billing statement. 2 days later, upon reporting the matter to the credit card company, he learned that a one-way airplane ticket was purchased online using his credit card for a flight to Milan in mid-August 2008. Upon extensive inquiry with the airplane company, Dante discovered that the plane ticket was under the name of one Dina Merrill. Dante approaches you for legal advice. Suppose an information is filed against Dina on August 12, 2008, and she is immediately arrested. What pieces of electronic evidence will Dante have to secure in order to prove the fraudulent online transaction? The suggested answer is he will have to present his report to the bank that he lost his credit card. Letter B, that the ticket was purchased after the report of the lost card. And the purchase of one-way ticket, Dante should bring an original or an equivalent copy printout of the online ticket purchase using his credit card, the phone call log to show that he already alerted the credit card company of his loss, and his credit card billing statement bearing the online ticket transaction. Thank you very much for listening. I hope you've learned a lot from this video. Have a wonderful day and may God bless you more. This has been Michelle. Bye.